Hi everybody, I'm Patrick Cauley with Keystone Elder Law. When families come to see me because they have a loved one who is going through a decline in health and the loved one needs long-term care, people tend to have a vague sense that Medicaid will pay for thousands and thousands of dollars every single month to cover the cost of their loved one's care. That's all true, and I guide them through that. What people tend not to understand as much is the obligation that the state agency has to get paid back when their loved one passes away. So when the Medicaid has paid for everything and the person eventually passes away, the government actually does make efforts to get paid back for all that care. So anticipating that payback is part of Medicaid planning. So I want to make clear just a few ideas about how you can protect assets even after your loved one is gone by some good planning in advance. So we're talking about probate property. Now, what does that mean? That means that whatever would be distributed through the loved one's will, so any bank accounts in their name, any house where their name is on the deed, their car, property that is theirs and theirs alone is what goes through probate. That's what happens to your will when you're gone. So that is what's the subject of that payback for Medicaid. Medicaid shows up like any other creditor after a person has passed away and they have a very large bill that they want to get paid. So they see what money is there to get paid back. So what's not subject to this payback to Medicaid? Well, first of all, any property that was placed into a trust, that doesn't go through probate. That's a private arrangement, and that's why elder law attorneys often use trusts to protect assets from Medicaid and the cost of long-term care. It prevents that payback at the end of the day because it doesn't go through probate. So a trust will protect a lot of property from that payback. What if it's jointly owned property with somebody else? So two spouses, for example, both their names are on the deed of the house. One goes into long-term care on Medicaid. Medicaid's not going to show up at the end of that Medicaid recipient's life and force the sale of the house if it's jointly owned with a surviving spouse. One word of caution though, what happens if the healthy spouse at home passes away while the other spouse is on Medicaid in long-term care? Once the Medicaid recipient passes away, that house is entirely in that person's name, and that's when the value of that house can be lost to the government instead of, for example, going to children, either the house itself or the proceeds from the sale of the house. So there's some planning there to get the name of the Medicaid applicant, Medicaid recipient off of the deed of the house when they go into a long-term care facility. So trusts, maybe changing names on the deed. These are ways to protect assets, keeping in mind that payback at the end of the Medicaid recipient's life. Irrevocable funeral reserves. So when you prepay your funeral, and I'll do a separate video on all the good reasons to do that, emotional and financial, any money you set aside in an irrevocable funeral reserve will be there to pay for your funeral, and then excess money that's not used on the funeral will go to a beneficiary such as your children, and that money will not be subject to the payback to the government. So that's a really important policy that we have in Pennsylvania because people should plan ahead for funerals, and that money should not then go back to the cost of care. It was set aside for a specific reason, and then children can take whatever's left without worrying about it going to pay back the government for care. Here's some really important exceptions to the payback to the government for money paid for long-term care. If there's a live-in caregiver, which is usually an adult child, lives in the home for at least 2 years, taking care of their parent, probably keeping them out of a nursing home for a longer period of time, the government will not swoop in and take that house if the child has made sacrifices to live in the home, save the government some money by caring for the parent in the home. The government will waive its claim forever and just allow that house to stay in the family because there was a live-in caregiver, usually an adult child. It could be a hardship waiver too. So what if there's an income producing property that the family has, and now that's part of the Medicaid recipient's estate when they pass away? Well, if the family can say, look, we don't have a lot of money, we depend on the income produced by this property, we can't have you take that away, we'll be crushed financially. If we can show all of that, and it really comes down to showing the finances of the family, that also will be an exception to the government's payback. They will not enforce this payback provision where it's going to crush a family financially. And finally, it's possible to get an exception from the payback out of a Medicaid recipient's estate if there's some third person, maybe an adult child, who's been paying the property taxes, paying to have somebody care for the properties, shovel snow, cut the grass, any sort of improvements to keep the home in good shape, whether it's for their loved one to return home or just to maintain the value of the property. If some other person has been putting money into the home, the government might waive its claim to get paid back by selling that house and taking the proceeds. So there's a lot to consider as far as the government getting paid back after the Medicaid recipient passes away. And if you have questions about that, I hope you'll reach out to me. You can send an email to info@Keystone Elder Law or reach out to us, KeystoneElderLaw.com. I'm Patrick Cauley. I'd be happy to answer any of your questions.